authority to determine what a just and reasonable rate is through a rulemaking or otherwise, but they've kept sections 206, 7, 9, 216, 217, and section 208, which are the basic common carrier complaint and related enforcement authority. And now cases can be heard either before the commission or in federal court. With respect to the federal court cases, what the commission did was to say, if a complaint is filed in federal court and it alleges that a practice or a charge is unjust or unreasonable, and we have not yet passed upon this issue, we will invoke our primary jurisdiction and request that the court refer the matter to us for a decision, and then it can go back to court. Before, none of your broadband internet access service was subject to this kind of enforcement authority. And of course, Title II enforcement allows for the imposition of monetary damages, attorney's fees, all the usual stuff that apply to common carriers. The commission also retained a handful of what it said were really important consumer protection provisions of Title II that are otherwise unrelated to net neutrality, but what the commission found was that once it reclassified, all provisions of Title II would apply unless it said they did it. And so then it became hard not to apply things like consumer privacy rules under Section 222, because the commission said privacy is really important to consumers on the internet, as we heard on the last panel, highly important as we move to the Internet of Things. So the commission retained its authority under Section 222. It has forborne from applying its own customer proprietary network information rules because it recognizes those were designed with voice telephony in mind, and they couldn't apply by their terms to internet access service, but it will develop new rules. In the meantime, you are subject to the statutory commands of Section 222 that you protect consumer privacy, but you're not going to have a lot of guideposts on how to do that. The commission has recently asserted very broad authority under this provision to fine a carrier for a data breach and a case of first impression. So data breaches are now subject to Section 222, and insofar as you are an internet access provider, you have a data breach with those customers' information to be subject to an enforcement action. So I caution that you be very careful with customer proprietary information, even though we're not entirely sure how this can be defined just yet. Another set of provisions the commission said, this is way too important to forbear from, are disabilities access. So now the disabilities access provisions in Title II apply to your internet service, with the exception that you do not now have to contribute to the Telecom Relay Service Fund for your internet revenues until the commission decides whether it's going to require you to do that in the future. The commission did retain its pole attachment authority under Section 224. And what it said was, this probably doesn't apply, this may or may not apply to you, but for cable operators who provided internet access in addition to cable service and VoIP, they were able to stay under the somewhat lower cable rate under a series of FCC decisions, Supreme Court case. Now the internet service has been classified as a telecommunications service, and they could be subject to requests from utilities that they now pay the telecom rate, which in many instances will produce a higher pole attachment rate. The commission recognized that this would be an unintended and not good consequence of reclassification, so it said, we want to make it very clear by this order, we didn't intend for utilities to raise their rates. Of course, there's nothing in the order to prevent them from doing so, and we'll have to rely on additional commission action should that occur to basically save people from having to pay higher rates. Section 254, Universal Service Support Authority, that applies, but the Commission has exercised forbearance for now from the carrier mandatory contribution requirement. So although you are now a common carrier for your internet access service, you don't have to immediately start paying into the Universal Service Fund on the basis of those revenues. The matter is still before the joint board in another proceeding. More to come on that. The major provisions of Title II that won't apply on this are listed on this slide. Basically, no tariffing. Commission will not set rates in advance. It won't require you to file Section 214 discontinuance applications. It's also exercised forbearance with respect to the market opening provisions included in the Telecom Act of 1996, resale, interconnection, unbundling, all of the market opening rules. However, the Commission said, we really don't need these specific rules because we have our Section 201 and 202 authority, and we can always order interconnection under that. So, yeah, we're not going to apply these specific, well-worked out standards for interconnection, but we may regulate your interconnection anyway. So I'm going to come to enforcement. As I've said a couple of times now, this is going to be case-by-case enforcement through investigation and processing of the informal and formal complaint. The net neutrality rules have their own complaint process, which is adopted in 2010 and not vacated by the court. For the three bright line rules, and I believe the general internet conduct standard, an aggrieved party can file a complaint under the 2010 Open Internet Complaint rules. These were based on the cable program access rules, and they're slightly less formal than the Section 208 Common Carrier Complaint formal complaint filing rules. But the Section 208 complaint rules remain available for anyone who wants to claim that you're violating any provision of Title II that has not been subject to forbearance, and that is 21 of those provisions. Substantial amount of delegation to the Enforcement Bureau staff to issue advisories, advisory opinions. They've created an ombudsperson to help consumers through the complaint process. They are actively encouraging complaints, in our opinion. If you request a staff advisory, you can only request an advisory concerning future conduct, not to get an exoneration for something you're already doing. Any advisory opinion you receive is not binding on the Commission. If they do issue these, they will be made public. You're not required to seek an advisory opinion, and our general advice is don't. It can't help you, and it could probably hurt. One other thing they've done, which is new and unusual, they've allowed the Enforcement Bureau, in the course of adjudicating a complaint, to request an opinion from an outside standard-setting body or expert on the practice that's complained of. So you could be in the middle of a complaint proceeding. The Enforcement Bureau could decide, I need a third party's opinion on this matter, and they can ask for that opinion, and if the opinion comes in, you can respond to it, and it will be part of your complaint record. Very unusual. So what happens next? As I said, the rules will go into effect 60 days after publication, with the exception of the enhanced transparency rules. We expect parties will not file petitions for reconsideration, but if they want to, they have 30 days from publication, Federal Register. We do expect many petitions for review in the Federal Courts of Appeals to be filed. Those are due within 60 days of Federal Register publication. parties could seek a stay of the effect of these rules. They're very hard to get. You have to demonstrate a likelihood of success on the merits of your case, and you have to show irreparable harm from the adoption of the rules. And for rules of general applicability like this, it's rather hard to get. So there are the courts, and then finally, there's the U.S. Congress, and I'll let Ross opine about that.
Great. Thank you, Barbara. I was